And I think that, for the women I know who have seen this movie who have experienced any similar pain.
Welcome to my channel. Well, there's been a lot of conversations about this subpoena. Did Stephanie Jones really respond to a subpoena from an actual court case? The answer is, it appears she did, but it's not from the kind of lawsuit that you would think. In fact, it was a lawsuit filed, I believe, by a company owned by none other than Blake Reynolds, aka Blake Lively. It has multiple branches, and Ryan Reynolds is almost assuredly involved in this. Ryan Reynolds and Blake Lively's company, Van Zandt Incorporated, an organization that they've incorporated, 10 or so years ago, filed a lawsuit, a very strange lawsuit against no one. Van Zandt Inc. against 1 through 10 inclusive as defendants. It says that the basis of Thevenue is CPLR 503A because plaintiff, principal place of business is in New York, Comm County, and then the address listed is the actual address of Van Zandt Incorporated, which is a company owned by Ryan Reynolds and Blake Lively. This was filed on September 27th. The subpoena, that has been shopped around to the Daily Mail by Stephanie Jones, stated that this came out of the Supreme Court of the Manhattan or New York County Court. This is where this was filed. And it said, the above named defendants have been served. Okay, so here you can see it was filed this company, Manette Phelps and Phillips. This is the company, or this is the law firm that actually represents Blake and Ryan Reynolds, plaintiff attorneys for Plaintiff Van Zandt Inc., filed at 628p. Emmett says they're attorneys. Manette Phillips and Phillips for this complaint. The action arises out of an ongoing campaign to damage plaintiff's business and plaintiff's reputation upon information and belief. The DOE defendants have certain contractual and confidentiality, obligations and obligations of faith, and loyalty to plaintiff regarding plaintiff's business and reputation by way of oral promises or written agreements. Despite these obligations, the DOE defendants have undertaken direct efforts to contravene these agreements, and instead have participated and may continue to participate in efforts to harm plaintiff, including by failing to act in plaintiff's best interests, taking actions to their personal benefit, at plaintiff's expense, failing to freely communicate with plaintiff regarding matters that impact plaintiff's business and reputation, and disclosing to third parties, and failing to keep strictly confidential plaintiff's confidential and/or private information. Interesting that the nature of the action derives out of them. Their business, Van Zandt Inc., which wasn't a part of this film, by the way. They're doing like this under the guise of it being a lawsuit, but so far nothing in this says anything about sexual harassment. It says they failed to act in the plaintiff's best interest, and instead they took actions for their own benefit at the plaintiff's expense. What does that sound like? It sounds like when Blake and Ryan wanted them to take the fall, right, for all of the negative press that Blake was getting, and they wanted them to put out that apology, and they said they refused to do so. And then they're claiming that they disclosed to third parties their private and confidential information. I don't know what they're even talking about there. This conduct constitutes breach of agreements and obligations owed by the DOE defendants to plaintiff, and Hascon caused significant reputational economic damages to the plaintiff. It seeks to recover compensatory economic, non-economic damages, as well as the other appropriate remedies against the DOE defendants. The plaintiff is a New York corporation with its principal business located in New York, and Thedos are individuals or companies that are doiseleld, that have their principal places of business in New York. And at this time, the plaintiff is not privy to the names or identities of the individual defendants, and therefore sues the defendants by such fictitious names. Upon information and belief, the DOE defendants are employees, contractors, agents, or representatives of plaintiff who have participated in and possibly conspired with others to scheme to damage plaintiff's business and reputation in breach of their oral and written promises to plaintiffs and their duties of good faith and loyalty to plaintiff. They said that they will, upon the figuring out who these people that are doing this, they'll change out the names and amend the pleadings. So they were trying to say that these were employees, contractors, agents, or representatives of Blake and Ryan. And they're saying they conspired with others to scheme to damage their reputations, and that they're breaching oral and written promises.
You're absolutely right. It is a terrible thing to say to any industry that you're in.
She didn't have a contract with Stephanie Jones. Stephanie was never her employee or a contractor, so they picked this jurisdiction because of their company or whatever. But they have no information here whatsoever. It's all based on information and belief. and it's wild upon information and belief. DO defendants have certain confidentiality, obligations to plaintiff regarding plaintiff's business, and reputation arising from, among other things, oral or written, agreements and her duties of good faith and loyalty. Collectively, the due duties. Specifically, plaintiff provided consideration to the DOE defendants in exchange for the DO defendants agreement to act in the plaintiff's best interest, not to take actions, to the plaintiff's expense and freely communicate with plaintiffs, regarding manners that impacted plaintiff's businesses and reputation and keep strictly confidential and not disclosed to third parties. Plaintiff's confidential or private information, upon information or belief in or around August 2024, before which is exactly around the time of when the film came out. The DOE defendants breached the DO duties by acting in a manner that was inconsistent with and damaging to the plaintiff's business, interests, and reputation. It almost sounds like they were going to sue their publicist, or they thought it was like a publicist. I don't understand this at all. It seems fake. But what do I know upon information of belief? The defendants' conduct included, but was not limited to failing to act in plaintiff's best interest, taking actions to their personal benefit, at the plaintiff's expense, failing to freely communicate with plaintiff regarding matters that impacted their business and reputation, and disclosing to third parties, and failing to keep strictly confidential plaintiff's confidential and/or private information. They claim that in or around August 24, these defendants disclosed plaintiff's confidential and private information to third parties. Is this supposed to be Stephanie Jones disclosing information to the Daily Mail, or this is odd, and thus far do you see anything about sexual harassment? No, it's about their reputations being harmed and their private information being disclosed. Nothing about sexual harassment upon information or belief in or around August 2024. The DOE defendants became aware of and failed to inform plaintiff about conduct by third parties that had a reasonable likelihood of causing, was designed to cause, or did cause irreparable harm to the plaintiff's business interests and reputation upon information and belief. With regard to foregoing, the DOE defendants have acted with negligence and reckless disregard of the impact that their acts and omissions have had and continue to cause monetary damages and irreparable harm to plaintiff's business interests and plaintiff's reputations. Plaintiff has suffered significant monetary damages and irreparable harm as direct result of their conduct. The first cause of action was breach of contract, nothing about sexual harassment. Again, upon information and belief, plaintiff and defendants are parties to oral and/or written agreements which impose certain confidentiality, obligations regarding plaintiff's business and reputation, and require the DOE defendants to act in their best interest, not take acts in bad faith to their personal benefit at plaintiff's expense, and freely communicate with plaintiff regarding matters that impact their businesses. It's all just the same things over and over. Again, because they don't have any allegations here. And they say they provided consideration to the DOE defendants in exchange for the DOE defendants' agreement to act in the plaintiff's best interest, not take actions in bad faith or to their personal benefit at plaintiff's expense. Freely communicate with plaintiff regarding matters that impacted their business and reputation, and keep strictly confidential and not disclosed to third parties. Confidential or private information. I almost wonder if what they're trying to say here is that they had a contract with Wayfair and they hadn't added them yet, but they're using this because they're preparing for a lawsuit. Because the consideration is that if you think about it, they promised that they would do everything for the plaintiff's best interest, and they would not take actions in bad faith for their personal benefit. So if we want to think of the letter as Brian Friedman Haskald of the extortion, they asked him to put out that they asked Baldoni Wayfair to put out that apology, and then they didn't. And so what they're saying here is that it could mean they're saying that they took actions in bad faith to benefit themselves and not to benefit Blake.
I don't see any malice in the in Baldoni suit, because there is a lot of evidence that maybe this.
And they somehow disclosed confidential information to third parties. Plaintiffs have either performed or was prevented or excused from performing by the actions of DOE defendants or the DO defendants agents all of the plaintiff's contractual obligations. So I think this was them trying to get out of their contract responsibilities with Wayfair and saying that their contractual obligations were waived because they were prevented from performing, and what they needed to do. They acted in a manner that was inconsistent with and damaging to the business interests and reputation, including and not limited by failing to act in the plaintiff's best interest, taking actions in bad faith to their personal benefit at their expense, and failing to freely communicate, and then disclosing third-party information to people confidential information that around August 2024, they became aware of and failed to inform plaintiff about conduct by third parties that had reasonable likelihood of causing and was designed to cause, and did cause monetary damages of irreparable harm. They breached their obligations to the plaintiff set forth in their respective written or oral agreements with plaintiff, and with regard to the foregoing, the defendants have acted with negligence and reckless disregard for of the impact or the acts of the omissions, and they will suffer and continue to suffer harm. It almost sounds like, again, they're trying to get out of a contract or trying to say that, like, we had a contract and I'm able to, like, sue you because of you breached the contract. It wasn't me that breached the contract, and you went off and disclosed information about me, and it hurt my image. And instead of you taking and doing what was in the best interest of me, you did what was in the best interest of you. And that makes me wonder if Wayfair knows about this. And this is why, the inconsideration part of that apology, they said was the precipitous of this whole lawsuit, because they refused to apologize. The second is breach of covenant of good faith and fair dealing, which is hilarious because they argued that Baldoni doesn't have anything against them in this specific same cause of action. They're parties to oral and written agreements which impose certain confidentiality, obligations regarding plaintiff's business, and reputations, and require defendants to act in plaintiff's best interest, not in their own blah blah blah. They're not supposed to speak about their confidential information and not disclose that to third parties. So it's like they're saying that someone broke an NDA and broke a contract by sharing their information with someone else. Plaintiff provided consideration to the DOE defendants in exchange for the DOE defendants' agreement to act in the plaintiff's best interest, not take actions to their personal benefit at plaintiff's expense, and freely communicate with plaintiffs regarding what the impact of these matters, and keep strictly confidential and not disclose to third parties their confidential and private information. So for whatever they think that they didn't want the sexual harassment stuff to come out or something, or again, there's nothing about sexual harassment here, it's all about their reputation being harmed. Plaintiff is informed and believes that the DOE defendants are deprived plaintiff of the benefits of their agreement, and thus breach their duty to deal fairly and in good faith by, among other things, acting in a matter that was inconsistent with and damaging to plaintiff's interests and reputations by disclosing confidential and private information about plaintiffs to third parties, and failing to inform them of information and conduct that was reasonable likelihood of causing irreparable harm to them and goodwill and reputation. They suffer and continue to suffer significant irreparable harm to their business and goodwill, as well as monetary damages. This is all about reputation. All about reputation. We asked you to do something. You didn't do it. You didn't act in our best interest. You didn't protect us. You gave out information about me. You breached this non-disclosure confidentiality agreement that we had, and it ruined my reputation. Third cause of action is faithless servant liability against 1 through 10 upon information and belief. Plaintiff and DOE defendants are parties to oral and written agreements. Again, obligations regarding plaintiff's business and reputation, and require the defendants to act in a plaintiff's best interest and not take actions in bad faith or to their personal benefit, to the detriment of plaintiff. Notwithstanding these contractual obligations, the DOE defendants engaged in misconduct and unfaithfulness by disclosing confidential and private information about plaintiff to third parties and failing to inform plaintiff of information and conduct that had reasonable likelihood of causing irreparable harm to plaintiff and plaintiff's goodwill and reputation.
And so he's out, and I just really wanted my husband, because I felt weird, like something was going on even though it wasn't. I was like, just wait.
What's the secret? What's the secret that they thought people were putting out there that caused damage to their reputation? What's the secret? Because in August, nothing was put out about Ryan or about Blake that was confidential. DOE defendants' conduct substantially violated their contracts of service with plaintiff, and such violations permeated the DOE defendants' service in their most material and substantial part, and were directly against plaintiff's interests. further as plaintiff's employees, contractors, agents, or representatives. The DO defendants owed plaintiff a duty of loyalty, which required them to exercise the utmost good faith and loyalty in their performance of their duties, prohibited them from acting in any matter inconsistent with the trust placed in them by plaintiff, and required them to keep confidential plaintiffs' private and/or confidential information as employees, contractors, agents, or representatives. Did they think Wayfair was their employee or a contractor or an agent or a representative? I mean, an agent representative would be like your PR person, your manager. So these were the people that were causing them harm. Or was it Wayfair? And all of this is about, you disclosed information about me that damaged my reputation. They were adverse to the plaintiff and constituted a breach of duties of good faith and loyalty owed to the plaintiff. Plaintiff has suffered and will continue to suffer damages as a result of their material violation of their contracts with plaintiff and their breaches of their duties of good faith and loyalty in the amount to be determined at trial as a result of their misconduct, unfaithfulness, contractual breaches, and violation of their duties of good faith and loyalty to plaintiff. Look at this ASA result of their misconduct, unfaithfulness, contractual breaches, and violation of their duties of good faith and loyalty. The DOE defendants, at minimum, forfeited the right to receive and are obligated to return to plaintiffany and all income they received from plaintiff from and after the commencement of the DO defendants' wrongdoing, including without limitational fees, bonuses, profits received in connection with their work for plaintiff in amount to be determined at trial. These bonuses and profits in their work for plaintiff. So first it was people that work for her, or did they think that they actually owned Wayfair? This is so confusing. The conduct underlying their breaches evinces a higher degree of moral turpitude and demonstrates such wanton dishonesty as to imply criminal indifference to their civil obligations. They want all money or income they made during the period of their wrongdoing income they received from plaintiff, but Blake didn't pay them any money. So did she think that Leslie Sloan was behind it? At first, Stephanie Jones wasn't her contractor. I mean, Maximum Effort, I guess, had a relationship with Wayfair. But all of this is about their reputation being harmed because of the disclosure of confidential information to third parties that they say higher damage their reputation so severely that it's ongoing, it's immoral, it's on the breach of being criminal. And again, nothing in here says anything about sexual harassment. It's about someone disclosing information that they didn't want to disclose and someone refusing to do what they wanted them to do and acted in their own best interests instead of acting for them to make them look better. Wherefore plaintiffs pray for judgment in the favor and for order requiring the defendants to return plaintiff all monies and any kind they receive from plaintiff from and after the commencement of the defendants' wrongdoing in connection with the work they performed for plaintiff. They wanted exemplary and punitive damage, pre- and post-judgment, interest by as permitted by law, and all cost for suit disbursement and reasonable attorney's fees. Okay, so this was filed on September 27th, 2024. Van Zandt Inc. is a company owned by Blake and Ryan Reynolds. Okay, what's even more interesting about this is, the case was withdrawn on December 19th, 2024, completely just withdrawn. They said without prejudice they were withdrawing it, they took it out. This was the only document filed in court. And then on December 19th, they withdrew it. December 20th, they go ahead and file a CRD complaint. December 21st, it goes public with the New York Times. There's nothing again in this document that says anything about sexual harassment. Stephanie Jones's attorneys have basically said that they released this information under a court-ordered subpoena because they had communications related to a case of retaliation against someone.
All monies and any kind they received from plaintiff from and after the commencement of the DO defendants
who was sexually harassed. And yet the case that the subpoena came from had nothing to do with sexual harassment and only anything to do with reputation. And what I believe this is, it's called a straw lawsuit. Basically what it is it's a fake lawsuit that's being weaponized to abuse the subpoena process. And it's one of the biggest red flags that can come up when legal battles get messy. So if someone files a straw lawsuit using a front person as the plaintiff in this case, they're using Van Zandt Inc., which is a defunct company in the state of New York that is inactive, and they're using this front company that has nothing to do with any of this. so they can use the power of the court to issue subpoenas for private communications, documents, or testimonies. They can use it to harass or intimidate third parties under the guise of discovery. They can fish for information that would otherwise be off-limits or hard to access, and they can damage reputations just by dragging someone's name into legal filings, even if lawsuits is weak or frivolous. So why this works is that this lawsuit, which is a fake lawsuit, was used to intimidate people to hand over records, and people feel like they're forced to comply. Even if the case isn't real, Blake wanted anything she could get about Baldoni so she could bury him. She wanted access to private and confidential communication that she never should have been able to obtain. Stephanie Jones says it was all about sexual harassment, and yet the straw lawsuit they used, apparently, is about Blake's reputation being harmed. This, and listen to this, this is from ChatGPT. This kind of tactic is more common in celebrity feuds, corporate smear campaigns, and political vendettas. Basically anywhere someone wants to keep their hands clean while causing legal chaos behind the scenes. So like Brian Friedman has said, what's the sham lawsuit that they used because there was no legitimate lawsuit that was filed? And then Stephanie Jones' publicist or attorney said that this was more distraction for the Wayfair parties. You or I, by the way. We can't just demand people hand over their private confidential communications. It's illegal. It violates the law to force people to hand over the communications that Blake got. And even under discovery purposes, the kinds of communications that she got could have been immediately quashed by a court because they were overbroad and invading someone else's privacy. And they used the straw lawsuit, and then they subpoenaed Stephanie on October. First, from that lawsuit, a company that has a forfeited status, mind you, in New York, an inactive business. And all it says is, you ruined my reputation, I did something for you, I want out of my contract, and now you're going to pay. Doesn't that sound a lot like what Justin Baldoni is suing Blake for the extortion of it all, and how his agent and their team basically said Sony and all of them said Blake and Ryan don't care. Someone's going to pay you, can't reason with them, they don't care, you need to apologize. This is what the case is all about. Wayfair said no to an apology because Blake's career and her reputation was hurt. She can get in trouble with the court. So you can get in trouble for filing a false straw lawsuit if it's proven that the lawsuit was filed in bad faith and for improper purposes. For instance, if it was frivolous, filed to harass or intimidate, or not based on a legitimate claim. If it's exposed to be a sham, the case can be thrown out permanently. Obviously, it's in this case already been withdrawn, but a bar complaint could be made against her lawyer that could face disciplinary action or disbarment. They could face countersuits against against Wayfair and others for malicious prosecution and abuse of process. I don't think they thought anyone was going to find this, but I bet you Friedman knows, and I bet you. That's why Wayfair is so confident. So what are your thoughts about this? Are you shocked? Are you not shocked? Are you surprised? Are you not surprised? Tell me in the comments below. Please make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.